the House Judiciary Committee this Wednesday morning, January 28th, and we're looking at draft number 2.2 of H626. It has been posted as well, and I'll turn it over to Michelle. Thank you for being here, and thank you for the quick turnaround on this revised draft.
So for the record, Michelle Childs, Office of Legislative Counsel, and as the chair mentioned, we're working off draft 2.2. The draft is highlighted, so I'm just going to go through the highlighted sections for you. So section 1 is the voyeurs and statute. You'll see on page 2, I added a definition of harm on there. This was a suggestion that was made by the Attorney General's office. They're not particularly engaged necessarily in this bill, but they were, kind of issue spotting there. There's a definition of harm in the dissemination of sexual explicit images without consent section, and so we're just screwing those two up.
Yeah.
The next changes are on page 6. And you'll see in subsection J under the penalties, there's just a little technical amendment there, but there was just a just incorrect cross-reference. So I'm just correcting that, but it's not changing things substantively. Section 2, which starts on page 7, is the statute on disclosure of sexual explicit images without consent. So if you turn to page 8, subsection B, so that's where we get to the elements of the offense. And so you'll see on line 12, I've struck threaten or coerce. So, you have a lot of elements in that particular crime. One of them is you have to do the act with the intent to harm, harass, intimidate, threaten, or coerce. So we've taken out threaten or coerce. So it would just be harm, harass, or intimidate. And that's because you've moved the threatening and coercion pieces into the new sexual extortion statute, which I'll get.
So should we do the walkthrough or questions as we go? Are you fine with questions as we go?
Sure.
Or do you want to just, right, okay.
Can I just thank you. Can we just back up so that I can follow you on the rest of it? Going back to page 2 on line 17, where you added, was serious emotional distress added? Because I'm trying to look on the original draft and I'm not finding it.
So this definition, the whole definition of subdivision 9, the definition of harm is added.
Thank you.
In here, and there is the same definition contained in section 2606 on dissemination of sexually explicit images without consent, and it relates to the provision on the civil action.
I'm just very happy to see that serious emotional distress in it. Thank you.
So, and then the other change that we just went over was just a technical change on the penalties on page 6. Nate, can you get Matt a copy so he can? Oh, sorry. So that's just a technical, fixing a typo. We just went over on page 8 in subsection B on the elements. So right now it has the intent to harm, harass, intimidate, threaten, or coerce. We're removing threats and coercion because that's now going into the new sexual extortion statute. The next changes, and I'll just note for you, is that you'll recall that previously the sexual extortion provisions were in 2606, but you wanted them moved out into a separate statutory section. So they are no longer appear in 2606, and they are now in this new section 3, which is creating a new section 2607 on sexual extortion. The language you have with regard to the offenses is the same. I did add a definition section because we needed to pull in those definitions that were in 2606 because we're using those same terms. We also added in the penalty section an enhanced penalty if a violation results in serious bodily injury or death. So we want to reference even though anybody who practices in criminal law knows what serious bodily injury is because it's used throughout the statutes, but I want to reference the definition that's in the that's in another part of the title. So you have on page 11, you have subsection A. So you have these definitions. Again, there's nothing new here. It just looks different. But from a policy perspective, I haven't changed anything. So I've just reorganized it. Subsection B is the offense with regard to knowingly threatening to disclose a visual image of an identifiable person who's nude or engaged in sexual conduct without the person's consent and with the intent to compel the person to either do something they don't want to do or refrain from doing something that they have a right to do. Subsection C is the provision with regard to with the intent to compel a person to create the images of nude images or of sexual conduct. Then the person, if they knowingly threaten to do something like physically injure the person or accuse the person of a crime, those types of things. Page 12, subsection D, which starts on line 4. Here's your penalty section. So you have 3 different penalties that are provided here. I'll remind you that the extortion statute that currently, that's kind of the general extortion statute that's in law, is a 5-year felony. So you'll see in subdivision D1, starting on line 4, it's a 5-year felony, $5,000 or both. If the victim is 18 years of age or older. Subdivision 2 is an enhanced penalty and goes up to 10 years and $10,000 if the victim of the offense is under 18 years of age. And then subdivision 3, there's no age component to that, but that if serious bodily injury or death results from a violation of the section, then it can be up to 15 years. So subsection E, this is modeling language that you have elsewhere in statute. As I mentioned yesterday, there's some in the prostitution chapter relating to if someone is either witnesses a crime or is a victim of a crime, that they can report, such a crime and then not be charged with certain things. You also have the Good Samaritan law in Title 18 around reporting a drug overdose that we discussed yesterday. So this is modeling that language. So it's not new to the statutes. And so it's a person who in good faith and in a timely manner reports to law enforcement that the person is a victim of a violation of sexual extortion statutes, is not to be cited, arrested, or prosecuted for a violation of essentially the provisions in the obscenity chapter that are dealing with dissemination or sharing of explicit images with respect to minors. So if, so showing a minor explicit images, or the sexting provision, which is 2802B. I don't know whether or not Dominica talked to you about whether, as part of your discussion yesterday, y'all talked about any of those things. But I think that was one of the things that was raised by one of the first witnesses about having, perhaps removing any potential liability or fear that someone would have that if, especially in regard to like teens were sexting one another pictures and wouldn't want to disclose that there's been a crime committed under the sexual extortion statute because they fear that they might be charged with a violation under the obscenity statutes. So subsection F is, again, just standard language that we have in the other immunity provisions in law, which is that it only applies to the use and derivative use of evidence gained as a proximate result of the reporting of the offense to law enforcement. And that the person is a victim of a violation of this section, and it doesn't preclude prosecution of the person on the basis of evidence obtained from an independent source. And so that's just so saying that, as related to that specific reporting, you can't use evidence gained through that. But if there's outside circumstances that relate to something else, some other offense that can be used. So page 13. Section 4, and this is on the criminal statute of limitations. And so just the things that are down in subsection C, so this is the extended time period of 40 years. I just added some cross references in there as a technical because that's kind of standard for us, and they weren't in there already. So those first subdivisions, 1, 2, and 3 are just technical clarifications. Let's see, on page 14, I've moved the offenses that you previously had that specific language earlier about, and that's been moved to the 40 years. So it's voyeurism involving photographing, filming, or recording. It's voyeurism involving display or disclosure of images to a third party, disclosure of sexually explicit images without consent. And I wasn't sure if y'all had discussed before the sexual extortion was in 2606, so it was applied, but then now it's its new stat, it's its own, so I applied that there. But these are all policy decisions for you about what you want to apply for the 40 years. And then just at the bottom of the page, I just retitled it. Now that sexual extortion is its own statute, and also because a lot of the testimony and focus of this has been around the creation of this new crime. And so I thought it would just be clear, to state up front in the title that sexual extortion is part of this proposal.
Questions? I've got a couple, and then, so going back to page 8 and line 11 and page 11 and line 8, 9. This is the, without the person's consent, you were going to think more about our suggestion of striking that language, and I'm wondering if
Was I supposed to think of that? Okay.
it's because we were going to have you strike that, and you said, well, let me think about that a little bit more. So,
Okay.
and our thought was that was unnecessary, because who's going to consent to the disclosure of image when the intent is to harm, harass, or intimidate, for instance, in B1 on page 8. And kind of the same rationale when you get to the page 11. So, but you were going to give that some more thought and why we might want to keep that. And we can get some more testimony as well on that. So that I'm just flagging that's still a question. I think the testimony that we've had suggested that why do we need to have that additional element in there?
Right.
Oh,
I can see it more on the.
Right, and the minor can't consent, that's nice, right? But
I can
That'll be with them.
see it initially more in either removal in the new extortion, but I want to think a little more about to be.
we got you halfway to where we need to go, so.
Put it in there for some reason.
So it's, yeah, striking out that, all right, my other question
Mhm.
is on page 12, line 10 to 12, and that's the serious bodily injury or death resulting.
Mhm.
We need to have a mens rea, do we need to have a scienter? I'm not using some Latin phrases. Like, or is it understood that it's based on recklessness? Or do we need to have?
I think it would be understood because you would look to the other places like where it's currently used in statute, but I think I'll take a look at that. And I think probably the witnesses from DSAS and Defender General can probably speak to that.
Okay, yeah, that's definitely one that I'd like to speak to. Other questions? Yeah, yes.
Quick one, I think. On that same page, page 12, line 13, this new immunity clause. Where it says, line 13, a person who in good faith and in a timely manner reports to law enforcement. I'm thinking about what we're doing with this statute of limitations.
Right. And I did kind of put a little note in here for myself about that, because again, I was trying to kind of model what we have currently, and some may not necessarily under these circumstances. It may not be appropriate, but I think you would want to talk to folks about that.
Yeah, because I guess that's my question is, in this context, what is a timely manner? And that's what
Where's the page in
page 12, line 13.
But Ian was first, so Barbara was first.
Barbara Denise?
So I have a question, but it's on existing language. that I'm, it's page 9, section C. The last part of that, so lines 8, 9, and 9. So the part where we say if requested by the depicted person, I'm almost wondering, like, that seems like that's really hard because the depicted person needs to know what sites this is popping up on and then know to say, don't put it up there. So I'm just wondering if it should be the opposite, like should not post unless they have received written permission from the depicted person. So that the burden isn't on the depicted person to try to figure out where the posting.
So you're saying like a website before anybody could put something on a website that the company would have to get permission?
I think websites
Or the-
are supposed to be, big
Yeah.
companies don't
They don't do, yeah.
look at that. I
So,
mean, that's a bigger,
right, like,
that,
That gets, yeah, that's.
I mean,
It-
that
it
is a good.
Great point.
it's just,
Yeah.
I'm just,
They don't control their content.
no, yeah.
It's not,
And what it sounds like is it gets taken down from one site and it pops up again on another site. And so, yeah, okay.
It's a
It just-
bigger,
I see the problem that you're pointing out, but I do think that is a much larger discussion in the context
I love
of
that.
relation
Yeah,
of
okay.
providers.
30 question conversation.
Yeah,
Let's
yeah,
talk
yeah.
about it.
Two quick things. One, page 12, line 1. We decided we're going to keep secret in.
Did I miss this yesterday?
Expose and expose an assertive, expose or publicize an asserted fact. So we're going to strike secret.
And then my only other question is, I should have asked this last time, and it just kind of came up in your walkthrough. So for a 40-year statute of limitations instead of like a discovery rule statute of limitations, just based on the testimony you heard today, if it's really unclear when exactly something happened, but like you can generally place it. So for example, we heard testimony this morning about a woman who she knew that she was in a relationship with this gentleman like approximately 10 years ago, and that this had happened sometime in that relationship, the recording. But like maybe
How do they pinpoint the commission of the offense?
And
The date of the commission of the offense?
if you can't,
Okay.
is that going to somehow impact an ability to bring it?
I would say the best thing is to talk to practitioners. They must face that now and try in those types of circumstances where if it's not clear when the date of the commission of the offense occurred.
I mean, that just said we shouldn't do the discovery. Right?
Well, that's, I guess, like it occurred to me that it's much cleaner to the date of the discovery. And if it causes any issue in bringing a criminal charge, if you can't pinpoint the date of the offense to be able to establish the term of the statute of limitations, that would be my concern.
Having a 40-year as opposed to.
Well, yeah, I mean, if it's not a problem, like if you can sort of go to a judge and be like, well, we know it kind of happened around 1998, but Your Honor, we can't tell you, like it could have been February, it could have been April, like is that
So
fine?
these events is only, so it doesn't do the viewing piece of the word.
Yep.
So it's just around the filming, the things that kind of
Yep.
are staying, right?
Yeah, so that's kind of where I could see it being pretty tricky to establish exactly when it happened,
When the initial disclosure happened.
or when the initial recording or
Right,
yeah.
but I would say that issue exists now. So I would say, how do practitioners deal with that now?
Yeah, but it's only 3 years,
Correct.
so probably easier than like 15.
True.
Yeah.
So, I mean, I would think that you might have similar problems with the discovery. When was the discovery? I mean, maybe that's easier to find.
Yeah, I guess presumably the discovery is from a party that is willing to work with you.
4 years.
Yeah, no, I don't know. Maybe it's not an issue. It just occurred to me based on what we heard this morning. That's it for me.
Yeah, have people comment on that as well. Other questions from Michelle? All right, so we can get some initial thoughts or maybe full thoughts from Department of State's attorneys, the network and Defender General. And if you all need a little more time as well and want to come back, we do have a time slot open this afternoon at 2:30. We were going to have this walkthrough, but we managed to get it in this morning. But we'll start with Kim.
You don't want to start with Matt since he's sitting in my chair.
Well, we can start with. Want to join us, or do you want to go after? See, as you're sitting in Michelle's chair anyway, so.
Yeah.
Do you need me to put my name?
Yeah.
Oh, boy. I can just do something.
It's the only place to have a desk in here.
Yeah, mine. Thank you for being here, Matt. I appreciate it.
Problem. My office is close.
But it's cold.
I'll tell you, I walked over here and it was a big, shiny, bright thing in the sky, which I didn't recognize.
Yes, I felt
But
the same.
I know it's 8 degrees out, but it felt warm.
It's all relative.
Not to say. For the camera, I'm Matt Valerio, Defender General. This doesn't look, well, it looks sort of like what I looked at. Let me just tell you generally, we don't have anything really to say about the bill. Practically, conceptually, I think I said something last week about it ought to be in the extortion statute, not in the voyeurism statute, because it really wasn't voyeurism, it was just kind of attached. And so I see that an attempt has been made at that, and obviously I haven't had time to go through it line by line to see if there would be a better way to write it or understand it. But conceptually, it doesn't offend anybody. I will say that I don't know, as a practical matter, that the Defender General's office doesn't really care much about the civil side of it. But as a lawyer who actually represented victims in the past and one time got $1 million judgment against somebody who attempted a sexual assault on an individual, my client. I don't know that the civil section really adds anything to existing law. If you just want to make a statement about something, that's fine. But I don't think it doesn't aid anything. It doesn't change what, if I were going to pursue a civil case, it doesn't add anything. From my review of that, I always get concerned when the legislature writes a statute in an area where existing law, common law tort would cover it, because then there is a question about whether or not there's a limitation on what types of claims could be made. Now, it's just, when the legislature delves into an area that, is broadly covered by civil tort law, and then puts like some either specific elements or requirements in it, courts look at it and say, they're trying to do something different. What exactly are they trying to do? But it is of no concern to the Defender General's office or our clients. I'm just telling you, as a lawyer who did this work before I did this work, that those things always make me wary, and so it's something to consider when you're trying to create a statutory tort as opposed to one that would be otherwise covered under common law, whether it be invasion of privacy or any number of other things that I could think of. The rest of it, I don't really have much to say about it. I 40-year statute of limitations is, I don't know what to say about it. There's not much to say about it. So the bottom line is there's no real concern with the concept. If I was going to go through this line by line, as any lawyer might, you might disagree about the way it would be written word for word. But we don't have any major concerns. Especially now that the extortion seems to be covered in extortion as opposed to in voyeurism, which might cause confusion or cause some states' attorneys to like not know where it is. Part of it is we have a lot of laws that are in Title 13. It's not, and some of our criminal laws are stretched over a couple of different volumes, but most of them are in Title 13. But it's like anybody else. If a state's attorney doesn't really know where to find it, then they can't use it, or they won't think of it. There was years ago, probably my first 10 years on this job, there was a state's attorney in Rutland who was a dear friend of mine who kept coming to me and saying, why didn't they criminalize that the precursors to meth? Like, Peter, we did this 5 years ago. Like he didn't, but he wasn't seeing it. I think it was in Title 18, not in Title 13. So he was getting, got confused. The guy had been a state's attorney for 20 years. It's just a matter of how our statutes are organized so that people can find it and it makes sense. And so by putting this in extortion, that's the way it should be done, in my opinion. It makes the rest of extortion, this type of extortion is like 3 times the length of the rest of the extortion statute, but maybe that's the way you want it. In any event, if you have any questions, like if you thought of something along the way, and I heard Michelle say that ask the Defender General about it, but I don't know what it was. So
I'll point you to the one page, it's page 8 and line 11. And we've had testimony and discussion about whether without the person's consent is language that is needed there in the knowingly disclose a visual image of an identifiable person who's nude or who's engaged in sexual conduct with the intent to harm, harass, or intimidate. It didn't seem to us that without the person's consent made much sense to have that requirement.
okay,
Any view on that?
no, not really.
Okay,
I don't know that it. See, I'd take out anything that doesn't add something. I don't know that adds anything.
that was view of someone else in here, so.
But reading it as a whole, I don't know that it hurts anything either, but
Right.
you always want to take out something that is surplus, because it can confuse judges.
There's fewer words. The other question I had is,
Well, they're trying to fashion jury instructions based on a new crime. And they're like, well, what does this mean? Is this an element? Is this a new, mental, what is it? And so they try to figure it out. And then, then ultimately the Supreme Court does. So if you have some specific thing you want done, and that doesn't add to it, then take it out.
you have a question, Michelle?
Can I just raise something? So I am in agreement, I think, on how it applies to the sexual extortion provision, but that language came from when it was earlier in 2606, and disclosure without the victim's consent is an important element of that crime. I get what you're saying in terms of, with the following being harass, intimidate, right? So that nobody would be consenting to something in that circumstance, but I would just be very cautious, and I would want to go back and look at, I think it's the Van Buren case, that was when there was an initial challenge to the statute and look at that because that's been an essential element of the offense for that kind of conduct, which is you have the images, they may have consented to, you having the images, but they didn't consent to the disclosure. So at this point, I wouldn't take it out of page 11.
You mean on page 8?
On page 8, that's right, sorry.
Yes.
Page 8.
So it's, doesn't quite read it. Maybe we need to look at what the jury instructions are.
But the difference,
Because,
Van Buren was a different crime. That was the voyeurism crime, and this is
Okay, right, yeah, okay.
extortion. So,
well, we'll still. put-
Well, on page 8, it's not.
So, yeah. Yeah. So if you take it out, then someone could consent to the photo being taken, consent to the disclosure of the photo, and then the disclosure of the photo causes harm. And now the question is, was the person who disclosed the photo, was their intent to cause the harm? Right? Right, well, I guess also the question is without the person's consent, is that consent for having had the photo taken, or was it consent to disclose? So it could be so that there's a little confusion that I have.
Oh, I guess I see that.
No, that,
It's knowingly disclose a visual image without the person's consent.
So I think that's.
So it's the disclosure, so it has
Yes.
nothing to do with whether there was consent. But again, it seems to be surplus because who's gonna get this consent to disclosure when the intent is to harm, harass, or intimidate? It's my point. I mean, you have to keep with the intent. Yeah, I consent to disclose, but that's because there's no intent to harm or harass or intimidate. That falls out of this. It would seem to me. But we will put a question mark and that'll be something that Michelle can give further thought and we can hear some more testimony from Kim and Charlie on that one as well. I'm gonna go to my other question unless we have more on that. So it's on page 12 and it's the line 10 to 12 that serious bodily injury or death resulting. And the question that I had is it understood that the scienter would probably in this instance be recklessness, that somebody is engaged in this extortion recklessly and or is that understood? Do we need to put a mens rea there? Do we,
that's not clear. This is one of those things where if I had a chance to look at it closely, the question is, could somebody interpret this as being a like strict liability situation? I wanted to embarrass the person, but they killed themselves or something, right?
I was extorting the person for any of these, for money and the person then died by suicide.
Guess you have to decide what you want to do.
Yeah, but I guess the question just is, should we be explicit that we're talking about a recklessness, essentially the same as a involuntary manslaughter type standard?
I think involuntary manslaughter is not reckless. It's negligent,
Okay, well,
but
manslaughter.
voluntary manslaughter would be reckless. If that's what you want to do. I mean, that's a choice. What are you trying to criminalize? So to me, at some point, that you have to have some kind of reasonably foreseeable result of what you are doing. And if you've got teenagers screwing around or very, relatively young people They spread around their, their picks from the party or whatever, with no, would it be reasonably foreseeable to them that somebody may end up dead, as a result of them doing that? Probably not. To me, what you want to do is determine how far down the road of foreseeability you want to go, or do you want to say, no, we're going to make this a strict liability kind of situation where if you do it, whatever happens next, that's your problem. So, my sense in general is that's not fair when you have young people who don't know what they're doing half the time anyway. But
And just to make clear, this isn't attached to just the disclosure of, this is with extortion. This is if somebody is extorting
Right.
somebody by threatening to disclose the new.
Right.
So there's a little more scienter than that kind of situation. Than-
right, what I always have worried about, and I've always talked about this when the original voyeurism statute was written, what was it, 20 years ago or so, was what happens with young people doing stupid things, as opposed to, 40-year-old people doing vicious things. And so that's the part I would be mindful of if I were you.
Right.
It's it's a matter of what you want to criminalize, or what kind of evil intent, or what degree of negligence, recklessness, simple negligence, nothing at all, make it strict liability. Like, those are all of the things you could do. But, my sense is you don't want to draw in, young people who do stupid things, who have no idea what they're doing.
Right.
And unfortunately, that's what, some of this is. And there's, a fair amount of it, something else too, so.
All right, fair enough. Any other questions from that? Not seeing any. Thank you very much. And if you have more to say on this,
Yeah, we'll go through it with a fine tooth comb and like that, but it's hard when you kind of just see it, so.
right, yeah. So I think we have a time slot. Well, we have this afternoon, but also I think tomorrow afternoon, if I'm not mistaken, and we'll double check.
Yeah, I'm not around tomorrow. I'm not in Montpelier tomorrow, but
So even if you can let me know if you want to weigh in any further on Friday, that's
yes, I
possible.
will be around Montpelier on Friday.
All right, thank you.
Thank you.
Thank you.
Thank you.
Right, so we'll hear from Kim.
So the Van Buren case was on 2606, not on lawyers. So on the dissemination of sexually explicit images without consent. So I sent that to you and look at the intent.
I'm looking at the jury check right now.
Pardon?
I'll take a look.
Thank you for being here. Identify yourself for the record and proceed.
Good morning, Kim McManus, Department of State's Attorneys and Sheriffs. Similar to the Defender General, I will give the caveat that I'd like to have a little bit more time just reading through the changes, though he's definitely made aware of the direction you all were heading in, and absolutely makes sense moving the sexual extortion section out of voyeurism. That all tracks. So just a few points. I believe I had raised this last week, though nobody remembers that I testified last week.
Friday
I'll raise it again. Please didn't remember. And this can absolutely be the committee's intent. I just wanted to point it out that Under the voyeurism changes on page 4, the disclosure to a third party.
You can tell us the lines that you're looking at as well.
Apologize, page 4, line 14 through 19. So somebody has done the filming and recording and now is disclosing it to a third party. That penalty, if you go to page 6, line 8, is 5 years, and fine not more than 5,000. Under the, sorry, see if I got this right. Under the disclosure of sexually explicit images statute, disclosing an image, so whether you've been the one who recorded it or not, just disclosing somebody's image, that's a misdemeanor of 2 years. So absolutely fine if the intent is that you've done the recording and then you just disclose it, that you want that higher penalty. I pointed it out last week that they're both disclosures. And again, facts and circumstances, a prosecutor may charge those differently, but just wanted to point out that they're similar in the disclosure piece and they have different penalties. But again, if it's because they've done the act of voyeurism and disclosing it, you have a higher penalty. That makes perfect sense and is rational. Just wanted to highlight to make sure that's what you wanted to do. Raised last week and again today, the without the person's consent. I'll happily read as well the Van Buren case again. I think this is extraneous to have the without the person's consent for both sections on page 8 and on page 11. I'll do a little bit more digging, and I know Ledge Council will be doing that.
Yeah, go ahead. Yeah.
So, I mean, the Van Buren case was one of the things that was focused on is the extreme invasion of privacy. And so it seems to me that like if you take out the without consent, right? So that's the difference, why there's this, difference between 2605 and 2606, right? Is that the voyeurism is nobody is consenting to the viewing, the filming, all this 2606. You could have been in complete agreement between the two parties as to the creation of the image, but there was not an intent for you to disclose. So it seems to me as though in order to kind of look at the Van Buren case, and I'll have to go back and read it myself, but that the fact that the person may have it is fine and completely separate out that they're disclosing without intent. I get what people are saying is that nobody would consent to be harassed or harmed or things like that, but I guess I'm not sure that it's been there all this time, and I don't know that there is a reason to remove it now and that it may jeopardize the delicate balance.
Right. Yeah. And
I mean, 2606 is called disclosure of sexually explicit images without consent. So I do feel like I see Michelle's point that in this section, and then further down on page 9, top of page 9, stating very clearly that consent to recording or production of the visual image does not by itself constitute consent for disclosure of the image. So I feel like there's a little more import here to that consent piece in this section. I would support taking it out from the sexual extortion. I think then that argument that like you can't possibly consent I don't think you can consent to being extorted. That's like oxymoronic. So I could see taking it out there, but.
well, yeah, and there is the argument that this has been law for, 6, 7, 8 years, something like that. And
Much longer.
even longer than that. So it's established. So is there a real reason to muck with it now? So that would be another
Have a
argument.
case that upholds it.
And we have a case that upholds it. So maybe that kind of satisfies that. For now, we'll consider leaving it despite good arguments to have.
Page 8, but page 11.
11, yeah, strike it,
That's-
page 11.
That is absolutely fair. The discussion. Oh, so page 12. For the penalty sections. I wonder if the committee would like to clarify in subsection D 1 and 2. This is line 4 through 9. It mentions whether the victim is over 18 or under 18. But I wonder if whether the offender is over or under 18, whether that impacts how you would like the penalty. Something just to highlight. For the if serious bodily injury or death, as Defender General said, this is a decision point for the committee. You could make the analogy to negligent operation, right? That as a community, we have decided if you negligently operate your vehicle and serious injury or death results, there is no additional mens rea there on the causation, like what caused that event. It's that you negligently operated and then the cause of events caused that serious bodily injury. So this would be akin to that. If you're saying that when someone knowingly threatens someone, and then the result is serious bodily injury, that this enhancement would be allowed. It would be on the, it would be argued whether that causation is there. That would have to be proven that the extorting caused that act, and it would be inherently difficult because there's an intervening actor, the person who has themselves. So it would be very much dependent on the facts and circumstances. But as written, we don't see a need for extra language right here. But again, that would be similar to how negligent operation death resulting is written.
I can ask a question about that specifically before you move on, if that's okay. And I'm thinking about the transcripts of these interactions that I've seen, and it's, very consistent. I can't say every time, but very consistent that the victim will say, please don't do this. I'm going to kill myself right now. And then there's the response is like, good, you should like go ahead. Like, is that the kind of proof that would be needed and, looked for to draw the direct connection?
That's going to be the type of evidence that's going to connect those events, right? The threatening and then the serious bodily injury or death. So I was listening to that testimony too and thinking, in those situations where it's, yeah, go ahead, you're already dead. Those sort of statements that, and the person saying that is more aware, right? That something potentially could happen to that person and that their actions are potentially causing that versus, if two teenagers are going back and forth in a chat and it's, there's no mention of harming yourself or hurting yourself or, you don't deserve to live anyway. Like if there's any of that sort of rhetoric in there, whether or not that would be enough evidence for that causation would depend. But that would be the type of thing that would weigh in favor of connecting those dots.
Okay, so would it be the existence of that type of evidence, the transcript or whatever that a prosecutor would look for, but making a charging decision?
It would really depend. I mean, that would be very
Right,
helpful, seeing that and knowing again that some actor was continuing to make these threats and the other person on the other end is saying things of self-harm. Again, that goes towards, can they connect that their actions could have this outcome? Similar to someone driving the wrong way on a highway, right? Odds are somebody might get hurt. That's how we connected those pieces. There was a conversation about statute of limitations that I was going to mention a few things, but I think with the 40-year piece, I think it's not, I think for prosecutors, as law enforcement said, that time frame absolutely helps the ability to prosecute these cases. There was a question, I think, about tolling of statute of limitations. So I just wanted to mention if there was a voyeurism case, someone here found out that someone had a video of them from a year ago. And right now it's a 3-year window. If this statute goes into effect during that 3-year window, then the new time limit attaches. So as long as your case, you're not outside of the statute of limit, you can kind of get into the next window for statute of limitations. So you can't go back, but anyone who's in the 3-year window right now, you would have more time on those cases right now.
A quick question, because we need to break.
Oh, yes, it is. Just about the timely manner, for this immunity on page 12, and maybe, okay, if this is in the new language, so if you want to spend more time with it.
Yeah, so here's what I suggest is, so this afternoon I do have some time set aside, but we're going to have a little more committee discussion about a couple of the things that came up for perhaps another revised version or not. At a minimum, we're going to be striking the without consent in that one section. And that'll give you, if you're available, and Charlie, if you're available this afternoon to weigh in, it's at 2:30, I think, is that what I have? Yeah, I have it down as at 2:30. And if you can't, and if you
30?
and if you can't, we also have this down at 2:00 tomorrow for some final discussion, hopefully wrapping it up. So we'll give you those two opportunities to wait for.
I'll be able to do tomorrow, not later.
Okay.
Okay.
Okay, all right, no problem. Thanks. All right, so at 1, we have some folks coming in to on H541, the interference with voters and election officials. We have a new draft given Rod Smola's, Professor Smola's input last week. It was very helpful. And we have a few witnesses on that as well. So